Hi everyone, I'm going to clarify right up front that this is not a relaxing topic, and I do not expect this video to be relaxing. It probably, if you're listening to it, will not help you sleep. I will not turn on ads or anything like that. I am not benefiting personally from this video. I am doing this as an act of solidarity and awareness raising. But the image behind me during this reading is an image of a grade school that was destroyed in a targeted bombing by Israel, which was situated in a refugee camp. I'm going to be reading from 4 speeches that were given at the International Court of Justice on Thursday, January 11th. South Africa has initiated proceedings against Israel to hold them accountable for a potential genocide. So the International Court of Justice is the international body that makes judgments on cases of genocide. I am going to put links to all of the speeches, videos of the speeches, a video of the entire court proceedings, and links to the transcript if you want to read of these proceedings in the description of this video. And I strongly recommend that you listen to the very brilliant, very accomplished, and very talented, speaking-wise lawyers who deliver these. So just go to my description and click those and listen. Usually I would say this for the sake of my, growing my channel, which I haven't been focusing on recently, but I'm saying this for the sake of boosting the message, is that leaving a like is very important. A comment, which many of you will probably want to leave anyway. Many of you might be very angry at me, but a comment helps. And on the page for this video, clicking the subscribe button. I am not asking you to subscribe for my benefit, but that makes a big difference in what YouTube deems worthy of being spread, and that goes for the videos that I link in my description. Final word before I get into the reading is, some may wonder, did I watch Israel's defense the following day? Yes, I did. And why am I not also reading Israel's defense? And the answer is that I live in the United States, and indeed many of you live in European countries and other countries whose media and whose political leaders have showed a blatant, egregious bias for the Israeli viewpoint, even to the point that CNN, anything CNN reports on Gaza has to be vetted by the Israeli government. That's the agreement they have. That is also the case for the New York Times, for example. The way the New York Times, and honestly most media outlets in my country have covered this, is to start with Israel denies allegations. And they pretty extensively covered what Israel has to say, and they did not give much detail on what was in South Africa, Africa's case. Also, for example, the BBC posted a video and live streamed Israel's entire proceedings, but did not do so for South Africa. Israel's perspective here does not need a boost. Speaking as an American, my president has now twice bypassed Congress to sell billions of dollars in weapons to Israel to help them commit the acts that are described in what I'm going to be reading. So I really don't think I need to give them another boost just for the sake of appearing balanced. Okay, the first speech I'm going to read is going to be by Adila Hassim on the acts that Israel has committed that qualify as genocidal. For quick context, this is a hearing for provisional measures, which are essentially emergency measures that need to be taken immediately, ordered by the court, to prevent a genocide from happening or continuing. These cases can take years. This one will likely take years. So they're They need to convince the court that it is plausible to say that a genocide is happening and that therefore we need to take measures immediately. This is Adila Hassim's speech. Madam President, distinguished members of the court, it is a privilege to appear on behalf of the Republic of South Africa in this case of exceptional importance. It is a case that underscores the very essence of our shared humanity as expressed in the preamble to the Genocide Convention. It is my task to address the court on the genocidal acts that have led to this urgent request for provisional measures under Article 41 of the Statute of the Court. South Africa contends that Israel has transgressed Article 2 of the Convention by committing actions that fall within the definition of genocide. The actions show a systematic pattern of conduct from which genocide can be inferred. Allow me to place these acts in context. Gaza is one of the two constituent territories of the occupied Palestinian territories, occupied by Israel since 1967. It is a narrow strip of approximately 365 square kilometers, as depicted in the map now displayed. Israel continues to exercise control over the airspace, territorial waters, land crossings, water, electricity, electromagnetic sphere, and civilian infrastructure in Gaza, as well as over key governmental functions. As the Honorable Minister has said, entry and exit by air and sea to Gaza is prohibited, with Israel operating the only two crossing points. Gaza, which is one of the most densely populated places in the world, is home to approximately 2.3 million Palestinians, almost half of them children. For the past 96 days, Israel has subjected Gaza to what has been described as one of the heaviest conventional bombing campaigns in the history of modern warfare. Palestinians in Gaza are being killed by Israeli weaponry and bombs from air, land, and sea. They are also at immediate risk of death by starvation, dehydration, and disease as a result of the ongoing siege by Israel, the destruction of Palestinian towns, the insufficient aid being allowed through to the Palestinian population, and the impossibility of distributing this limited aid while bombs fall. This conduct renders essentials to life unobtainable. At this provisional measures stage, as this court has made clear in the Gambia v. Myanmar case, it is not necessary for the court to come to a final view on the question of whether Israel's conduct constitutes genocide. It is necessary to establish only whether at least some of the acts alleged are capable of falling within the provisions of the Convention. On analyzing the specific and ongoing genocidal acts complained of, it is clear that at least some, if not all, of these acts fall within the Convention's provisions. These acts are documented in detail in South Africa's application and confirmed by reliable, often United Nations sources. It is thus unnecessary and impossible for me to recount all of them. I will highlight only some in order to illustrate the pattern of genocidal conduct. The United Nations statistics that are relied upon are up to date as of 9 January 2024. In South Africa's oral submissions, we will illustrate the facts that we rely on with limited use of audiovisual material. Madam President, we do so with restraint and only where necessary, and always with respect to the Palestinian people. Against this background, I move now to demonstrate in turn how Israel's conduct violates Articles 2A, 2B, 2C, and 2D of the Convention. The first genocidal act committed by Israel is the mass killing of Palestinians in Gaza in violation of Article 2A of the Genocide Convention. As the UN Secretary General explained 5 weeks ago, the level of Israel's killing is so extensive that nowhere is safe in Gaza. As I stand before you today, 23,210 Palestinians have been killed by Israeli forces during the sustained attacks over the last 3 months, at least 70% of whom are believed to be women and children. Some 7,000 Palestinians are still missing, presumed dead under the rubble. Palestinians in Gaza are subjected to relentless bombing wherever they go. They are killed in their homes, in places where they seek shelter, in hospitals, in schools, in mosques, in churches, and as they try to find food and water for their families. They have been killed if they failed to evacuate, in the places to which they have fled, and even while they attempted to flee along Israeli-declared safe routes. The level of killing is so extensive that those whose bodies are found are buried in mass graves, often unidentified. In the first 3 weeks alone following 7 October, Israel deployed 6,000 bombs per week. At least 200 times, it has deployed 2,000-pound bombs in southern areas of Palestine designated as safe. These bombs have also decimated the north, including refugee camps. 2,000-pound bombs are some of the biggest and most destructive bombs available. They are dropped by lethal fighter jets that are used to strike targets on the ground by one of the world's most resourced armies. Israel has killed an unparalleled and unprecedented number of civilians, with a full knowledge of how many civilian lives each bomb will take. More than 1,800 Palestinian families in Gaza have lost multiple family members, and hundreds of multi-generational families have been wiped out, with no remaining survivors. Mothers, fathers, children, siblings, grandparents, aunts, cousins, often all killed together. This killing is nothing short of destruction of Palestinian life. It is inflicted deliberately. No one is spared, not even newborn babies. The scale of Palestinian child killings in Gaza is such that United Nations chiefs have described it as a graveyard for children. The devastation we submit is intended to and has laid waste to Gaza beyond any acceptable legal, let alone humane, justification. The second genocidal act identified in South Africa's application is Israel's infliction of serious bodily or mental harm to Palestinians in Gaza in violation of Article 2B of the Genocide Convention. Israel's attacks have left close to 60,000 Palestinians wounded and maimed. Again, the majority of them women and children. This in circumstances where the healthcare system has all but collapsed. I return to this later in my speech. Large numbers of Palestinian civilians, including children, are arrested, blindfolded, forced to undress, and loaded onto trucks taken to unknown locations. The suffering of the Palestinian people, physical and mental, is undeniable. Turning to the third genocidal act under Article 2C, Israel has deliberately imposed conditions on Gaza that cannot sustain life and are calculated to bring about its physical destruction. Israel achieves this in at least 4 ways. First, by displacement. Israel has forced the displacement of about 85% of Palestinians in Gaza. There is nowhere safe for them to flee to. Those who cannot leave or refuse to be displaced have either been killed or are at extreme risk of being killed in their homes. Many Palestinians have been displaced multiple times, as families are forced to move repeatedly in search of safety. Israel's first evacuation order on 13 October required the evacuation of over 1 million people, including children, the elderly, the wounded and infirm. Entire hospitals were required to evacuate, even newborn babies in intensive care. The order required them to evacuate the north to the south within 24 hours. The order itself was genocidal. It required immediate movement, taking only what could be carried, while no humanitarian assistance was permitted, and fuel, water, and food and other necessities of life had been deliberately cut off. It was clearly calculated to bring about the destruction of the population. For many Palestinians, the forced evacuation from their homes is inevitably permanent. Israel has now damaged or destroyed an estimated 355,000 Palestinian homes, leaving at least 500,000 Palestinians with no home to return to. The Special Rapporteur on the Human Rights of Internally Displaced Persons explains that houses and infrastructure have been razed to the ground, frustrating any realistic prospects for displaced Gazans to return home, repeating a long history of mass forced displacement of Palestinians by Israel. There is no indication at all that Israel accepts responsibility for rebuilding what it has destroyed. Instead, the destruction is celebrated by the Israeli army. Soldiers film themselves joyfully detonating entire apartment blocks and town squares, erecting the Israeli flag over the wreckage, seeking to re-establish Israeli settlements on the rubble of Palestinian homes, and thus extinguishing the very basis of Palestinian life in Gaza. Second, together with the forced displacement, Israel's conduct has been deliberately calculated to cause widespread hunger, dehydration, and starvation. Israel's campaign has pushed Gazans to the brink of famine. An unprecedented 93% of the population in Gaza is facing crisis levels of hunger. Of all the people in the world currently suffering catastrophic hunger, more than 80% are in Gaza. The situation is such that the experts are now predicting that more Palestinians in Gaza may die from starvation and disease than airstrikes. And yet Israel continues to impede the effective delivery of humanitarian assistance to Palestinians, not only refusing to allow sufficient aid in, but removing the ability to distribute it through constant bombardment and obstruction. Just 3 days ago, on 8 January, a planned mission by United Nations agencies to deliver urgent medical supplies and vital fuel to a hospital and medical supply center was denied by Israeli authorities. This marked the 5th denial of a mission to the center since 26 December, leaving 5 hospitals in northern Gaza without access to life-saving medical supplies and equipment. Aid trucks that are allowed in are seized upon by the hungry. What is provided is simply not enough. Madam President, members of the court, this is an image of an aid truck arriving in Gaza. Third, Israel has deliberately inflicted conditions in which Palestinians in Gaza are denied adequate shelter, clothes, or sanitation. For weeks, there have been acute shortages of clothes, bedding, blankets, and critical non-food items. Clean water is all but gone, leaving far below the amount required to safely drink, clean, and cook. Accordingly, the WHO has stated that Gaza is experiencing soaring rates of infectious disease outbreaks. Cases of diarrhea in children under 5 years of age have increased 2,000% since hostilities began. When combined and left untreated, malnutrition and disease create a deadly cycle. The fourth genocidal act under Article 2b is Israel's military assault on Gaza's healthcare system, which renders life unsustainable. Even by 7 December, the United Nations Special Rapporteur on the Right to Health noted that the healthcare infrastructure in the Gaza Strip has been completely obliterated. Those wounded by Israel in Gaza are being deprived of life-saving medical care. Gaza's healthcare system, already crippled by years of blockade and prior attacks by Israel, is unable to cope with the sheer scale of the injuries. Finally, the United Nations Special Rapporteur on Violence Against Women and Girls has pointed to acts committed by Israel that would fall under the fourth category of genocidal acts in Article 2d of the Convention. On 22 November, she expressly warned the following: the reproductive violence inflicted by Israel on Palestinian women, newborn babies, infants, and children could be qualified as acts of genocide under Article 2 of the Genocide Convention, including imposing measures intended to prevent births within a group. Israel is blocking the delivery of life-saving aid, including essential medical kits for delivering babies, in circumstances where an estimated 180 women are giving birth in Gaza each day. Of these 180 women, the WHO warns that 15% are likely to experience pregnancy or birth-related complications and need additional medical care. That care is simply not available. In sum, Madam President, all of these acts, individually and collectively, form a calculated pattern of conduct by Israel, indicating a genocidal intent. This intent is evident from Israel's conduct in specially targeting Palestinians living in Gaza, using weaponry that causes large-scale homicidal destruction, as well as targeted sniping of civilians, designating safe zones for Palestinians to seek refuge and then bombing these, depriving Palestinians in Gaza of basic needs: food, water, health care, fuel, sanitation, and communications, destroying social infrastructure, homes, schools, mosques, churches, hospitals, and killing, seriously injuring, and leaving large numbers of children orphaned. Genocides are never declared in advance, but this court has the benefit of the past 13 weeks of evidence that shows incontrovertibly a pattern of conduct and related intention that justifies a plausible claim of genocidal acts. In the Gambia v. Myanmar case, this court did not hesitate to impose provisional measures in relation to allegations that Myanmar was committing genocidal acts against the Rohingya within the Rakhine State. The facts before the court today are sadly even more stark, and like the Gambia-Myanmar case, deserve and demand this court's intervention. Every day there is mounting irreparable loss of life, property, dignity, and humanity for the Palestinian people. Our news feeds show graphic images of suffering that has become unbearable to watch. Nothing will stop this suffering except an order from this court. Without an indication of provisional measures, the atrocities will continue, with the Israeli Defense Forces indicating that they intend pursuing this course of action for at least a year. In the words of the United Nations Under-Secretary General on 5 January 2024, "You think getting aid into Gaza is easy? Think again. 3 layers of inspections before trucks can even enter. Confusion and long queues. A growing list of rejected items. A crossing point meant for pedestrians, not trucks. Another crossing point where trucks have been blocked by desperate, hungry communities. A destroyed commercial sector. Constant bombardments. Poor communications. Damaged roads. Convoys shot at. Delays at checkpoints. A traumatized and exhausted population crammed into a smaller and smaller sliver of land. Shelters which have long exceeded their full capacity. Aid workers themselves displaced, killed. This is an impossible situation for the people of Gaza and for those trying to help them. The fighting must stop." Madam President, members of the court, that concludes my section on the genocidal conduct of Israel. Next, I will read the statements of Tembeka Ngcukaitobi, who is reading evidence of Israel's genocidal intent, that is, evidence that Israel intends to destroy in all or in part the Palestinian people in Gaza as such. I don't know if I clarified this yet, but under the Genocide Convention, to deem something a genocide, there has to exist both genocidal acts and you have to be able to prove intent, that Israel, in this case, intends to destroy Palestinians in Gaza as a people. Madam President and distinguished members of the court, it is a privilege to appear before the court on behalf of South Africa. I will address Israel's genocidal intent. At this stage, the court is not required to determine that the only inference to be drawn from the available evidence is genocidal to order provisional measures, as that is to decide the merits. Rather, the assessment of the existence of an intent to destroy could be made by the court only at the stage of the examination of the merits. That some of the alleged acts may also amount to atrocities other than genocide does not exclude the finding of plausible acts of genocide. Madam President, South Africa is not alone in drawing attention to Israel's genocidal rhetoric against Palestinians in Gaza. 15 United Nations Special Rapporteurs and 21 members of the United Nations working groups have warned that what is happening in Gaza reflects, quote, "a genocide in the making," end quote, and an overt intent to, quote, destroy the Palestinian people under occupation. End quote. Israel has a genocidal intent against the Palestinians in Gaza. That is evident from the way in which Israel's military attack is being conducted, which has been described by Ms. Hassim SC. It is systematic in its character and form. The mass displacement of the population of Gaza, herded into areas where they continue to be killed, and the deliberate creation of conditions that lead to a slow death. There is also the clear pattern of conduct, the targeting of family homes and civilian infrastructure, laying waste to vast areas of Gaza, and the bombing, shelling, and sniping of men, women, and children where they stand, the destruction of the health infrastructure, and lack of access to humanitarian assistance, so much so that as we stand today, 1% of the Palestinian population in Gaza has been systematically decimated, and 1 in 40 Gazans have been injured since 7 October. These two elements alone are capable of evidencing Israel's genocidal intent in relation to the whole or part of the Palestinian population in Gaza. However, third, there is an extraordinary feature in this case, that Israel's political leaders, military commanders, and persons holding official positions have systematically and in explicit terms declared their genocidal intent. And these statements are then repeated by soldiers on the ground in Gaza as they engage in the destruction of Palestinians and the physical infrastructure of Gaza. We show this third element next. Israel's special and genocidal intent is rooted in the belief that in fact the enemy is not just the military wing of Hamas, or indeed Hamas generally, but is embedded in the fabric of Palestinian life in Gaza. On 7 October, in a televised address, Israeli Prime Minister Benjamin Netanyahu declared war on Gaza. Israel had started clearing out the communities that had been infiltrated by terrorists, in his words, and he warned of an unprecedented price to be paid by the enemy. There are more than 2.3 million Palestinians in Gaza. Israel is the occupying power in control of Gaza. It controls entry, exit, and the internal movements inside Gaza. And qua Prime Minister, Mr. Netanyahu exercises overall command over the Israeli Defense Forces and in turn the Palestinians in Gaza. Prime Minister Netanyahu, in his address to the Israeli forces on 28 October 2023, preparing for the invasion of Gaza, urged the soldiers to, quote, remember what Amalek has done to you, end quote. This refers to the biblical command by God to Saul for the retaliatory destruction of an entire group of people known as the Amalekites. Put to death men and women, children and infants, cattle and sheep, camels and donkeys. The genocidal invocation to Amalek was anything but idle. It was repeated by Mr. Netanyahu in a letter to the Israeli Armed Forces on 3 November 2023. Madam President, let the Prime Minister's words speak for themselves. The Deputy Speaker of the Knesset, Israel's parliament, has called for the erasure of the Gaza Strip from the face of the earth. The Defense Force agrees. On 9 October, the Defense Minister Yoav Gallant gave a situation update to the army where he said that as Israel was imposing a complete siege on Gaza, quote, there would be no electricity, no food, no water, no fuel. Everything would be closed. because Israel is, quote, fighting human animals. Speaking to troops on the Gaza border, he instructed them that he has released all the restraints and that Gaza won't return to what it was before. We will eliminate everything. We will reach all places. Eliminate everything. Reach all places without any restraints. The theme of destruction of human animals was reiterated by an Israeli army coordinator of government activities in the territories, Kogat, on 9 October 2023, who, in an address to Hamas and the residents of Gaza, stated that Hamas has become ISIS and that the citizens of Gaza are celebrating instead of being horrified. He concluded that human animals are dealt with accordingly. Quote, Israel has imposed a total blockade on Gaza. No electricity, no water, just damage. You wanted hell, you will get hell. End quote. The language of systematic dehumanization is evident here. Human animals. Both Hamas and civilians are condemned. Within the Israeli cabinet, this is also a widely held view. The Minister of Energy and Infrastructure, Israel Katz, called for the denial of water and fuel, as this is what will happen to a people of children killers and slaughterers. This admits of no ambiguity. It means to create conditions of death of the Palestinian people in Gaza, to die a slow death because of starvation and dehydration, or to die quickly because of a bomb attack or snipers, but to die nevertheless. In fact, Heritage Minister Amichai Eliyahu stated that Israel, quote, must find ways for Gazans that are more painful than death. End quote. It is no answer to say that neither are in command of the army. They are ministers in the Israeli government. They vote in the Knesset and are in a position to shape state policy. The intent to destroy Gaza has been nurtured at the highest levels of state, as President Isaac Herzog has joined the ranks of those signing bombs destined for Gaza. Aside, because this didn't immediately register when I first listened to him as an intuitive thing, but people in Israel have been putting their signatures and writing messages onto bombs, which are then dropped on Palestine, no doubt many of which have killed children. Continuing, the intent to destroy Gaza has been nurtured at the highest levels of state, as President Isaac Herzog has joined the ranks of those signing bombs destined for Gaza, having previously noted that the entire population in Gaza is responsible and that, quote, this rhetoric about civilians not aware, not involved, is absolutely not true. We will fight until we break their backbone, end quote. Later attempts by the president and others to neutralize this speech have not altered the sting of his words, which was to tar all Palestinians as responsible for the actions of Hamas, nor, as I will show below, has it affected how state policy is understood within government. The Minister of National Security repeated the president's statements that Hamas and civilians are responsible in equal measure. On 10 November 2023, in a televised interview, he stated that, quote, when we say that Hamas should be destroyed, it also means those who celebrate, those who support, and those who hand out candy. They're all terrorists, and they should also be destroyed. End quote. These are orders to destroy, and to maim what cannot be destroyed. These statements are not open to neutral interpretations or after-the-fact rationalizations and reinterpretations by Israel. The statements were made by persons in command of the state. They communicated state policy. It is simple. If the statements were not intended, they would not have been made. The genocidal intent behind these statements is not ambiguous to the Israeli soldiers on the ground. Indeed, it is directing their actions and objectives. On 7 December 2023, Israeli soldiers proved that they understood the Prime Minister's message to remember what the Amalek has done to you as genocidal. They were recorded by journalists dancing and singing. We know our motto, there are no uninvolved. That they obey one commandment, to wipe off the seed of Amalek. The video you're seeing on the screen, no sound, is the video that was played at the sitting. And you can read the captions to see the example he's discussing. The Prime Minister's invocation of Amalek is being used by soldiers to justify the killing of Palestinians, including children. These are the soldiers repeating the inciting words of their Prime Minister. Israeli soldiers in Gaza were filmed dancing, chanting, and singing in November. May their village burn. May Gaza be erased. There is now a trend among the soldiers to film themselves committing atrocities against civilians of Gaza in a form of snuff video. One recorded himself detonating over 50 houses in Shujaya. Other soldiers were recorded singing, "We will destroy all of Khan Yunis and this house. We will blow it up for you and for everything you do for us." These are the soldiers putting into effect their command. The commanders of the army are also of the same mind. Israeli Army Commander Yair Ben David has stated that the army had done in Beit Hanun and did there as Shimon and Levi did in Nablus, and that the entire Gaza should resemble Beit Hanun. I think it was Levi, not Levi, excuse me. Israeli soldier Yishai Shalev published a video against the backdrop of the ruins of what was the site of Al-Azhar University with the caption, "Once upon a time there was a university in Gaza, and in practice, a school for murderers and human animals." Soldiers obviously believe that this language and their actions are acceptable because the destruction of Palestinian life in Gaza is articulated state policy. Senior political and military officials encouraged without censure the 95-year-old Israeli army reservist Ezra Yashin, a veteran of the Deir Yassin massacre against the Palestinians in 1948, to speak to the soldiers ahead of their ground invasion in Gaza. In his tour, he echoed the same sentiment while being driven around in an official Israeli army vehicle dressed in Israeli army fatigues. Quote, "Be triumphant and finish them off, and don't leave anyone behind. Erase the memory of them. Erase them, their families, mothers, and children. These animals can no longer live. If you have an Arab neighbor, don't wait. Go to his house and shoot him. We want to invade, not like before. We want to enter and destroy what's in front of us and destroy houses, then destroy the one after it. With all of our forces, complete destruction. Enter and destroy. As you can see, we will witness things we've never dreamed of. Let them drop bombs on them and erase them." As recently as 7 January 2024, a video of a soldier was posted online where he boasts that the army had destroyed the entire village of Herbet Aza. For 2 weeks, he said, they had worked hard to bomb the village and executed their mandate. Any suggestion that senior politicians did not mean what they said, much less that the meaning was not understood by soldiers in Gaza, would be without any merit. The scale of destruction in Gaza, the mass targeting of family homes and civilians, the war being a, quote, war on children, all make clear that genocidal intent is both understood and is being put into practice. The articulated intent is the destruction of Palestinian life in all its manifestations. The genocidal rhetoric is also commonplace within the Israeli Knesset. Members of the Knesset, MKs, have repeatedly called for Gaza to be wiped out, flattened, erased, and crushed on all its inhabitants, in those words. They have deplored anyone, quote, feeling sorry for the, quote, uninvolved Gazans, asserting repeatedly that there are no uninvolved, that there are no innocents in Gaza, that the killers of the women and children should not be separated from the citizens of Gaza, that, quote, the children of Gaza have brought this upon themselves, end quote, and that there should be one sentence for everyone there, death. Finally, the lawmakers have called for mercilessly bombing from the air, with some advocating for the use of nuclear weapons, and, quote, a Nakba that will overshadow the Nakba of 48. Aside, if you don't know what the Nakba is, Nakba, you can look that up. It's important. Continuing, the Prime Minister's genocidal speech has gained ground among some elements of civil society. A famous singer has repeated Mr. Netanyahu's Amalek reference, stating that Gaza must be wiped out and destroyed with every Amalek seed. We simply must destroy all of Gaza and exterminate everyone who is there. Another has called to erase Gaza, not leave a single person there. Journalists and commentators have announced that the woman is an enemy, the baby is an enemy, the pregnant woman is an enemy, that it is necessary to turn the strip into a slaughterhouse, to demolish every house our soldiers come across, exterminate everyone. The intentional failure of the government of Israel to condemn, prevent, and punish such genocidal incitement constitutes in itself a grave violation of the Genocide Convention. We should recall, Madam President, that in Article 1 of the Convention, Israel confirmed that genocide, whether committed in time of peace or in time of war, is a crime under international law, and it undertook to prevent and punish it as such. This failure to prevent, condemn, and punish such speech by the government has served to normalize genocidal rhetoric and extreme danger for Palestinians within Israeli society. As MK Moshe Sada from the Likud party has said, the government's own attorneys share his views that Palestinians in Gaza must be destroyed. I quote, "You go anywhere, and they tell you to destroy them. In the kibbutz, they tell you to destroy them. My friends at the state attorney's office, who fought with me on political issues in debates, said to me, it is clear that we need to destroy all Gazans." End quote. Destroy all Gazans. Israel is aware of its destruction of Palestinian life and infrastructure. Despite this knowledge, it has maintained, and indeed intensified, its military activity in Gaza. As to full awareness, in the week after 7 October, non-governmental organizations in the United Nations warned of an unprecedented humanitarian crisis in Gaza. the United Nations stated that actors must allow humanitarian teams and goods to immediately and safely reach the hundreds of thousands of people in need. So right from the beginning, Israel knew that it was depriving food, water, electricity, and essentials for survival. It said so. Everything is closed. It has known that it was depriving Palestinians of health care and treatment for injury in the middle of an unprecedented bombardment, of food and water, and of other essentials for survival. This prompted the World Health Organization to say, "We are on our knees asking for sustained, scaled-up, protected humanitarian operations," appealing to all those in a situation to make a decision or influence decision makers to give us the humanitarian space to address this human catastrophe. Despite this knowledge, Israel continues to target infrastructure essential for survival: water and sanitation infrastructure, solar panels, bakeries, mills, crops. It bombs hospitals, decimating the healthcare system. It targets aid workers and the infrastructure of the United Nations. It is because of the policy of Israel that Gaza has become a place of, quote, death and despair. In conclusion, Madam President, many propagators of grave atrocities have protested that they were misunderstood, that they did not mean what they said, and that their own words were taken out of context. What state would admit to a genocidal intent? Yet the distinctive feature of this case has not been the silence as such, but the reiteration and repetition of genocidal speech throughout every sphere of state in Israel. We remind the court of the identity and authority of the genocidal inciters: the Prime Minister, the President, the Minister of Defense, the Minister of National Security, the Minister of Energy and Infrastructure, members of the Knesset, senior army officials, and foot soldiers. Genocidal utterances are therefore now out in the fringes. They're embodied in state policy. The intent to destroy is plainly understood by soldiers on the ground. It is also fully understood by some within the Israeli society, with the government facing criticism for allowing in any aid to Gaza, on the basis that it is recanting on its promise to starve Palestinians. Any suggestion that Israeli officials did not mean what they said, or were not fully understood, by soldiers and civilians alike, to mean what they said, should be rejected by this court. The evidence of genocidal intent is not only chilling, it is also overwhelming and incontrovertible. Okay, just to be clear, I am doing this in 2 sittings. I've just finished Tembeka Ngcukaitobi's remarks on Israel's genocidal intent, and now I will be moving on to Blinne Ní Ghrálaig's remarks on irreparable prejudice to the rights in this case. Roughly, Ms. Ní Ghrálaigh is talking about the risk of irreparable damage, the continuation of a potential genocide that will allow, that will cause rights to be violated in irreparable ways if provisional measures are not granted. Madam President, members of the court, there is an urgent need for provisional measures to protect Palestinians in Gaza from the irreparable prejudice caused by Israel's violations of the Genocide Convention. The United Nations Secretary General and its chiefs described the situation in Gaza variously as a crisis of humanity, a living hell, a bloodbath, a situation of utter deepening and unmatched horror, where an entire population is besieged and under attack denied access to the essentials for survival on a massive scale. As the United Nations Under-Secretary General for Humanitarian Affairs stated last Friday, quote, "Gaza has become a place of death and despair. Families are sleeping in the open as temperatures plummet. Areas where civilians were told to relocate for their safety have come under bombardment. Medical facilities are under relentless attack. The few hospitals that are partially functional are overwhelmed with trauma cases, critically short of all supplies, and inundated by desperate people seeking safety. A public health disaster is unfolding. Infectious diseases are spreading in overcrowded shelters as sewers spill over. Some 180 Palestinian women are giving birth daily amidst this chaos. People are facing the highest levels of food insecurity ever recorded. Famine is around the corner. For children in particular, the past 12 weeks have been traumatic. No food, no water, no school, nothing but the terrifying sounds of war, day in and day out. Gaza has simply become uninhabitable. Its people are witnessing daily threats to their very existence, while the world watches on." End quote. The court has heard of the horrific death toll and of the more than 7,000 Palestinian men, women, and children reported missing, presumed dead, or dying slow, excruciating deaths trapped under the rubble. Reports of field executions and torture and ill treatment are mounting, as are images of decomposing bodies of Palestinian men, women, and children, left unburied where they were killed, some being picked upon by animals. It is becoming ever clearer that huge swathes of Gaza, entire towns, villages, refugee camps, are being wiped from the map. As you have heard, but it bears repeating, according to the World Food Program, quote, 4 out of 5 people in the world, in famine or a catastrophic type of hunger, are in Gaza right now, end quote. Indeed, experts warn that deaths from starvation and disease risk significantly outstripping deaths from bombings. The daily statistics stand as clear evidence of the urgency and of the irreparable prejudice. On the basis of the current figures, on average 247 Palestinians are being killed and are at risk of being killed each day, many of them literally blown to pieces. They include 48 mothers each day, 2 every hour, and 117 children each day, leading UNICEF to call Israel's actions a war on children. On current rates, which show no sign of abating, each day, over 3 medics, 2 teachers, more than 1 United Nations employee, and more than 1 journalist will be killed, many while at work, or in what appear to be targeted attacks on their family homes or where they are sheltering. The risk of famine will increase each day. Each day, an average of 629 people will be wounded, some multiple times over, as they move from place to place, desperately seeking sanctuary. Each day, over 10 Palestinian children will have one or both legs amputated, many without anesthetic. Each day, on current rates, an average of 3,900 Palestinian homes will be damaged or destroyed. More mass graves will be dug. More cemeteries will be bulldozed and bombed and corpses violently exhumed, denying even the dead any dignity or peace. Each day, ambulances, hospitals, and medics will continue to be attacked and killed, The first responders who have spent 3 months without international assistance trying to dig families out of the rubble with their bare hands will continue to be targeted. On current figures, one will be killed almost every second day, sometimes in attacks launched against those attending the scene to rescue the wounded. Each day, yet more desperate people will be forced to relocate from where they are sheltering, or will be bombed in places where they had been told to evacuate to. Entire multi-generational families will be obliterated, and yet more Palestinian children will become WCNSF. Wounded Child, No Surviving Family. The terrible new acronym born out of Israel's genocidal assault on the Palestinian population in Gaza. There is an urgent need for provisional measures to prevent imminent, irreparable prejudice to the rights in issue in this case. There could not be a clearer or more compelling case. In the words of the Commissioner General of the United Nations Relief and Works Agency, there must be an end to the decimation of Gaza and of its people. Turning to the court's case law, as the court has recently reaffirmed, quote, the condition of urgency is met when acts susceptible of causing irreparable prejudice can occur at any moment before the court makes a final decision on the case. End quote. That is precisely the situation here. Any of those matters to which I have referred can and are occurring at any moment. United Nations Security Council resolutions demanding the immediate, safe, unhindered delivery of humanitarian assistance at scale throughout Gaza and full, rapid, safe, and unhindered humanitarian access remain unimplemented. United Nations General Assembly resolutions calling for a humanitarian ceasefire have been ignored. The situation could not be more urgent. Since these proceedings were initiated on 29 December 2023 alone, an estimated over 1,703 Palestinians have been killed in Gaza and over 3,252 injured. As to the criterion of irreparable prejudice, for decades now, the court has repeatedly found it to be satisfied in situations where serious risks arise to human life or to other fundamental rights. In the cases of Georgia v. Russia and Armenia v. Azerbaijan, the court ordered provisional measures having found a serious risk of irreparable prejudice where hundreds of thousands of people had been forced from their homes. In ordering provisional measures in the latter case, the court noted the context of the long-standing exposure of the population to a situation of vulnerability, including hindrances to the importation of essential goods, causing shortages of food, medicine, and other life-saving medical supplies. In Gaza, as you have heard, nearly 2 million people, over 85% of the population, have been repeatedly forced to flee their homes and shelters, not just once or twice, but some 3, 4, or more times over, into shrinking slivers of land, where they continue to be bombed and killed. This is a population that Israel had already made vulnerable through 16 years of military blockade and crippling de-development. Today, Israel's hindrances to the import of food and essential items have brought Gaza to the brink of famine, with adults, mothers, fathers, grandparents, regularly foregoing food for the day so that children can eat at least something. Medicine shortages and the lack of medical treatment, clean water, and electricity are so great that large numbers of Palestinians are dying or are at imminent risk of dying preventable deaths. Cancer and other services have long shut down. Women are undergoing cesarean sections without anesthetic in barely functioning hospitals described as scenes from a horror movie, with many undergoing otherwise unnecessary hysterectomies in an attempt to save their lives. In the Canada and the Netherlands v. Syria torture case, the court made clear that individuals subject to torture and other acts of cruel, inhuman, or degrading treatment or punishment are at serious risk of irreparable prejudice. Palestinians in Gaza are also at risk of such irreparable prejudice, with videos of Palestinian boys and men rounded up and stripped and degraded broadcast to the world, alongside footage of serious bodily harm and accounts of serious mental harm and humiliation. In Qatar v. United Arab Emirates, the court considered provisional measures to be justified, having regard to the risk of irreparable prejudice deriving from factors such as people being forced to leave their places of residence without the possibility of return, the psychological distress of temporary or potentially ongoing separation from their families, and the harm associated with students being prevented from taking their exams. If provisional measures were justified there, how could they not be in Gaza, where countless families have been separated, with some family members evacuating under Israeli military orders, and others staying behind at extreme risk to care for the wounded, infirm, and the elderly, where husbands, fathers, and sons are being rounded up and separated from their families, taken to unknown locations for indeterminate periods of time. In the Qatar case, the court issued a provisional measures order where harm to approximately 150 students was an issue. In Gaza, 625,000 school children have not attended school for 3 months, with the United Nations Secretary Council expressing deep concern that the disruption of access to education has a dramatic impact on children, and that conflict has lifelong effects on their physical and mental health. Almost 90,000 Palestinian university students cannot attend university in Gaza. Over 60% of schools, almost all universities, and countless bookshops and libraries have been damaged or destroyed, and hundreds of teachers and academics have been killed, including deans of universities and leading Palestinian scholars, obliterating the very prospects for the future education of Gaza's children and young people. Notably, the court has found provisional measures to be justified in all 3 cases where they were previously sought in relation to violations of the Genocide Convention. It did so in Bosnia v. Serbia in 1993, finding, on the basis of evidence that was certainly no more compelling than that presently before the court, that it was sufficient to determine that there was a grave risk of acts of genocide being committed. The court found provisional measures to be justified in the Gambia v. Myanmar case, on the basis of a risk of irreparable prejudice to the Rohingya subjected to mass killings, as well as beatings, the destruction of villages and homes, denial of access to food, shelter, and other essentials of life. More recently, in indicating provisional measures in Ukraine v. Russian Federation, the court considered that Russia's military activities had resulted in numerous civilian deaths and injuries and caused significant material damage, including the destruction of buildings and infrastructure, giving rise to a risk of irreparable prejudice. The court had regard to the fact that attacks are ongoing and are creating increasingly difficult living conditions for the civilian population, which it considered to be extremely vulnerable. The The court also considered the fact that many persons have no access to the most basic foodstuffs, potable water, electricity, essential medicines, or heating, and that many were attempting to flee under extremely insecure conditions. This is occurring in Gaza on a much more intensive scale, to a besieged, trapped, terrified population that has nowhere safe to go. Lest the contrary be suggested, it is clear from Ukraine v. Russian Federation that the fact that the urgent risk of irreparable harm arises in a situation of armed conflict does not undermine, much less preclude, a request for provisional measures. That is also clear from the court's other judgments. In the case of armed activities on the territory of the Congo, Democratic Republic of the Congo v. Uganda, for example, the court ordered provisional measures based on its finding that persons, assets, and resources present on the territory of the Congo, particularly in the area of conflict, remain extremely vulnerable, and that there was a serious risk that the rights at issue in this case may suffer irreparable prejudice. Similarly, in Costa Rica versus Nicaragua, the court indicated provisional measures in part on the basis that the presence of troops in the disputed territory gave rise to a real and present risk of incidents liable to cause irremediable harm in the form of bodily injury or death. In relation to the Genocide Convention in particular, the court recalled in the Gambia v. Myanmar case that states parties expressly confirmed their willingness to consider genocide as a crime under international law, which they must prevent and punish independently of the context of peace or of war in which it takes place. More recently, in the Guyana v. Venezuela case, the court considered that the serious risk of Venezuela acquiring and exercising control and administration of the territory in dispute gave rise to a risk of irreparable prejudice to the rights asserted in the case. Similar factors are an issue here, having regard to the territorial ambitions and settlement plans for Gaza being raised by members of the Israeli government, and the relationship of those factors to the very survival of Palestinians in Gaza as such. Similarly, any scaling up by Israel of access to humanitarian relief to Gaza in response to these proceedings, or otherwise, would be no answer to South Africa's request for provisional measures. In the case of Iran v. United States, the court found a risk of irreparable harm from the exposure of individuals to danger to health and life, caused by restrictions placed on medicines and medical devices, foodstuffs, and other goods required for humanitarian needs. That was notwithstanding the assurances offered by the United States for it to expedite the consideration of humanitarian issues, and notwithstanding the fact that essentials were in any event exempt from the United States sanctions. The court considered that the assurances were not adequate to address fully the humanitarian and safety concerns raised, and that there remained a risk that measures adopted by the United States may entail irreparable consequences. In Armenia v. Azerbaijan, unilateral undertakings to alleviate restrictions alongside the full resumption of humanitarian and commercial deliveries did not defeat a request for the indication of provisional measures. The court was clear that while contributing towards mitigating the imminent risk of irreparable prejudice resulting from the military operation, those developments did not remove the risk entirely. Indeed, in Georgia v. Russian Federation, the court made clear that it considers a serious risk to subsist where the situation is unstable and could rapidly change. The court considered that given the ongoing tension and the absence of an overall settlement to the conflict in this region, populations also remain vulnerable. Israel continues to deny that it is responsible for the humanitarian crisis it has created, even as Gaza starves. The aid it has belatedly begun to allow in is wholly inadequate and does not come anywhere close to the average 500 trucks being permitted daily before October 2023, even under the blockade. Any unilateral undertakings Israel might seek to give about future aid would not remove the risk of irreparable prejudice, not least considering Israel's past and current conduct toward the Palestinian people, including the 16 years of brutal siege on Gaza. In any event, as the United Nations Secretary General has made absolutely clear, it is a mistake to measure the effectiveness of the humanitarian operation in Gaza based on the number of trucks allowed in. As he stressed, the real problem is that the way Israel is conducting this offensive means that the conditions for the effective delivery of humanitarian aid no longer exist. That would require security, staff who can work in safety, logistical capacity, and the resumption of commercial activity. It requires electricity and steady communications. All of these remain absent. Indeed, only shortly after Israel opened the Kerem Shalom crossing to goods in late December 2023, it was struck in a drone attack, killing 5 Palestinians and leading to another temporary closure. Nowhere and nobody is safe. As the United Nations Secretary General and all its chiefs have made clear, without a halt to Israel's military operations, crossings, aid, convoys, and humanitarian workers, like everyone and everything else in Gaza, remain at imminent risk of further irreparable prejudice. An unprecedented 148 United Nations staff have been killed to date. Without a halt to Israel's military activity in Gaza, there will be no end to the extreme situation facing Palestinian civilians. Madam President, members of the court, if the indication of provisional measures was justified on the facts in those cases I have cited, how could it not be here, in a situation of much greater severity, where the imminent risk of irreparable harm is so much greater? How could they not be justified in a situation that humanitarian veterans from crises spanning as far back as the killing fields of Cambodia, people who, in the words of the United Nations Secretary General, have seen everything, if they say it is so utterly unprecedented that they are out of words to describe it? It would be a complete departure from the long and established line of jurisprudence that this court has firmly established and recently reconfirmed, for the court not to order provisional measures in this case. The imminent risk of death, harm, and destruction that Palestinians in Gaza face today, and that they risk every day during the pendency of these proceedings, on any view justifies, indeed compels, the indication of provisional measures. Some might say that the very reputation of international law, its ability and willingness to bind and to protect all peoples equally, hangs in the balance. But the Genocide Convention is about much more than legal precedent. It is also fundamentally about the confirmation and endorsement of elementary principles of morality. The court recalled the 1946 General Assembly resolution on the crime of genocide, which made clear that, quote, genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these human groups, and is contrary to moral law and to the spirit and aims of the United Nations. Notwithstanding the Genocide Convention's recognition of the need to rid the world of the odious scourge of genocide, the international community has repeatedly failed. It failed the people of Rwanda. It had failed the Bosnian people and the Rohingya, prompting this court to take action. It failed again by ignoring the early warnings of the grave risk of genocide to the Palestinian people, sounded by international experts since 19 October of last year. The international community continues to fail the Palestinian people, despite the overt dehumanizing genocidal rhetoric by Israeli government and military officials, matched by the Israeli army's actions on the ground. Despite the horror of the genocide against the Palestinian people being live-streamed from Gaza to our mobile phones, computers, and television screens, the first genocide in history where its victims are broadcasting their own destruction in real time, in the desperate, so far vain, hope that the world might do something. Gaza represents nothing short of a moral failure, as described by the usually circumspect International Committee of the Red Cross. As underscored by United Nations chiefs, that failure has, quote, repercussions not just for the people of Gaza, but for the generations to come who will never forget these over 90 days of hell and of assaults on the most basic precepts of humanity, end quote. As stated by a United Nations spokesperson in Gaza last week, at the site of a hospital clearly marked with a symbol of the Red Crescent, where 5 Palestinians, including a 5-day-old baby, had just been killed. The world should be absolutely horrified. The world should be absolutely outraged. There is no safe space in Gaza, and the world should be ashamed. Madam President, members of the court, in conclusion, I share with you 2 photographs. The first is of a whiteboard at a hospital in northern Gaza, one of the many Palestinian hospitals targeted, besieged, and bombed by Israel over the course of the past 3 brutal months. The whiteboard is wiped clean of no longer possible surgical cases, leaving only a handwritten message by a Médecins Sans Frontières doctor which reads, "We did what we could. Remember us." The second photograph is of the same whiteboard after an Israeli strike on the hospital on 21 November that killed the author of the message, Dr. Mahmoud Abu Nujayla, along with 2 of his colleagues. Just over a month later, in a powerful sermon, delivered from a church in Bethlehem on Christmas Day, the same day Israel had killed 250 Palestinians, including at least 86 people, many from the same family, massacred in a single strike on Maghazi refugee camp. Palestinian pastor Munther Isaac addressed his congregation on the world, and he said, quote, "Gaza as we know it no longer exists. This is an annihilation. This is a genocide. We will rise. We will stand up again from the midst of destruction, as we have always done as Palestinians, although this is by far maybe the biggest blow we have received," end quote. But he said, "No apologies will be accepted after the genocide. What has been done has been done. I want you to look at the mirror and ask, where was I when Gaza was going through a genocide?" South Africa is here before this court in the Peace Palace, It has done what it could. It is doing what it can by initiating these proceedings, by seeking interim measures against itself as well as against Israel. South Africa now respectfully and humbly calls on this honorable court to do what is in its power to do, to indicate the provisional measures that are so urgently required to prevent further irreparable harm to the Palestinian people in Gaza, whose hopes, including for their very survival, are now vested in this court. Okay, the final section I will be reading will be Vaughan Lowe's case, describing the provisional measures that are being sought. That is what they're requesting that Israel will be ordered to do to prevent the continuation of a genocide in Gaza and its justification. This one is a little more legal focused, but for one, he's a really good speaker. You should listen to his speech, linked in the bio or description. And I think there are also a lot of good points to extract from this, and also a lot of moral points to be extrapolated from it. And so I wanted to include that as the last section. Madam President, members of the court, it is a privilege to appear before you, and an honor to do so on behalf of the Republic of South Africa. This case is brought under Article 9 of the Genocide Convention, which entitles any contracting party to the convention to submit to the court disputes relating to the interpretation, application, or fulfillment of the convention. The court does not at this stage have to determine whether or not Israel has or has not acted contrary to its obligations under the Genocide Convention. That can only be done at the merits stage. It is concerned now only with the question of what provisional measures are required pending the court's final decision on the merits. The court's jurisprudence points to 5 requirements for the ordering of provisional measures. The first is that there should be a prima facie jurisdiction. That was addressed by Professor Dugard. The second is that there should be a link between the measures requested and the rights underlying the main claim. This requirement is plainly satisfied. The measures request an order that Israel does not violate the very rights secured by the Genocide Convention, as set out in South Africa's application. The third is the plausibility of the rights that are claimed. Professor Duplessis explained that this is clearly satisfied. The rights claimed are the very core of the convention, notably the right not to be killed or seriously harmed, and the right of the group not to be physically destroyed. Fourth and fifth, there must be a risk of irreparable prejudice capable of arising prior to the final determination of the dispute, and there must be urgency. Ms. Ní Ghrálaigh addressed those points. Israel has, for over 3 months, been mounting a continuous siege and bombardment of Gaza of a ferocity and duration that can only be seen as an attempt to destroy Gaza and its citizens. And it is publicly asserting that it will continue to do so. You are aware of the scale of the death and the scale of the destruction, and it is continuing at this very minute. The court has said that, quote, a state's obligation to prevent genocide and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it means likely to have a deterrent effect on those suspected of preparing genocide, or reasonably suspected of harboring specific intent, it is under a duty to make such use of these means as the circumstances permit. That is what South Africa has done by making this application. In cases such as Legrand, Avina, and Jadov, This court has exercised its power to order provisional measures having regard to the impact not only of provisional measures on the state's parties to a case, but also to the impact on the individuals directly affected and their rights. It has issued orders to restrain states from killing individuals in a manner alleged to violate international law. And that is what South Africa is requesting after more than 22,000 individuals have already been killed in the siege and bombardment of Gaza, the overwhelming majority of them innocent men, women, and children. The court also issues orders to safeguard the integrity of its proceedings and the efficacy of its final ruling. In the Bosnia genocide case, for example, you ordered that the parties, quote, not take any action and ensure that no action is taken which may aggravate or extend the existing dispute over the prevention or punishment of the crime of genocide, or render it more difficult of solution. Without such non-aggravation orders, there is a real risk that a respondent will rush to complete its unlawful conduct before the court's final ruling, thus rendering the ruling and the court an irrelevance. South Africa has kept its application in this case within the scope of the convention. First, some will ask why South Africa does not seek any court order against Hamas. This case concerns Israel's actions in Gaza, which is territory that, 3 weeks ago in Resolution 2720, the United Nations Security Council stressed is, quote, an integral part of the territory occupied in 1967 by Israel, end quote. As the court will understand, Hamas is not a state and cannot be a party to the Genocide Convention, and cannot be a party to these proceedings. There are other bodies and processes that can address the questions of steps to be taken in respect of past atrocities and against other actors, and they are no doubt considering what they should do. But as a matter of law, under the convention, South Africa cannot request an order from this court against Hamas. Secondly, South Africa understands that not all violence constitutes genocide. Acts of ethnic cleansing, collective punishment, the targeting of civilians, attacks on hospitals, and other war crimes are all unlawful. But they do not always violate the Genocide Convention. Genocide requires an intent to destroy, in whole or in part, a national, ethnical, racial, or religious group. But the fact that what Israel is doing in Gaza may also constitute war crimes or crimes against humanity is no defense and no bar to a charge of genocide. South Africa has set out its request for relief in paragraph 111 of its application, and its request for provisional measures in paragraph 144. The reasoning behind the requests is pragmatic. The first 2 paragraphs of the provisional measures request call for the suspension of Israel's military operations in and against Gaza. Israel's continuing operation in Gaza since the 7 October attack is the focus of this case. Minister Lamola has recalled the fact that South Africa has condemned the 7 October attack. Israel says that Palestine and Palestinians are not its target and that its aim is to destroy Hamas. But months of continuous bombing, flattening entire residential blocks and cutting off food and water and electricity and communications to an entire population cannot credibly be argued to be a manhunt for members of Hamas. It is an indiscriminate attack, killing, maiming, and terrorizing the entire population of Gaza with no regard to questions of innocence or guilt. obliterating the homes and cities in which they live, and destroying any practical possibility of their return to make their homes amidst the rubble. Israel actions both attack Palestinians in Gaza directly and also prevent humanitarian relief reaching them. Palestinians face death from continuing bombardments and shootings, and death from starvation and disease, which is even more indiscriminate, but usually slower. In recent days, the United States has said again that far too many civilians are being killed, and the United Nations Secretary General, the United Nations Under-Secretary General for Humanitarian Affairs, and the Commissioner General of UN Relief and Works Agency have asserted that it is imperative to halt military operations in order to enable the effective delivery of humanitarian relief. That is why South Africa has requested an order for the immediate suspension of Israel's military operations in and against Gaza. It is the only way to secure the humanitarian response and avoid yet more unnecessary death and destruction. There is a point to emphasize. It is no use Israel saying that it does whatever it can to minimize the deaths of innocent men, women, and children. The use of 2,000-pound bunker-busting bombs and dumb bombs in residential areas, and the relentless bombardment of Gaza, and even of so-called safe areas to which Palestinians have been directed by Israel, tell another story. But that is not the only point. It is not just a question of scale and indiscriminate killing. It is also a question of intention. If any military operation, no matter how carefully it is carried out pursuant to an intention to destroy a people in whole or in part, it violates the Genocide Convention, and it must stop. That is why all military operations capable of violating the Genocide Convention must cease. The third request is for an order that both Israel and South Africa, in accordance with their obligations under the Genocide Convention in relation to the Palestinian people, take all reasonable measures to prevent genocide. The fourth and fifth measures then spell out these general obligations in terms of the specific instances of offenses listed in Articles 1, 2, and 3 of the Convention. The sixth requested measure addresses the fact that, aside from its own acts, the government of Israel is legally bound to prevent and punish others who engage in, or incite, or actively support conduct that violates the Genocide Convention. Until the reported intervention of the Attorney General 36 hours ago, Israeli authorities appear to have done practically nothing to stop the flow of genocidal rhetoric, including statements emanating from the ranks of public officials. Indeed, the toleration, even normalization, of such incitement has become a matter of concern within Israel itself. That is why this measure is sought. This case is important. Lives are at stake. Israel's credibility and reputation are at stake. Yet evidence that could determine whether or not particular acts violate the Genocide Convention is being lost or destroyed, while fact-finders and foreign journalists are unable to report freely from Gaza. Hence the seventh request, which is for an order directing the preservation of evidence. Finally, South Africa asks that the court requires specific reports from Israel on what it is doing to implement the order. General assurances are not enough. Reports published via the court are an essential element of accountability. I should address the question of self-defense. In its advisory opinion on the Wall case, the court noted that the threat that Israel had argued justified the obstruction of the wall, the construction of the wall, was not imputable to a foreign state but emanated from territory, the occupied Palestinian territory, over which Israel itself exercises control. For those reasons, the court decided that as a matter of international law, the right of self-defense under Article 51 of the United Nations Charter had no relevance in such circumstances. 20 days ago, the Security Council affirmed yet again that Gaza is occupied territory. Though Israel refers to a complete withdrawal from Gaza, it has retained control over Gaza, over access by land, sea, and air, and over key governmental functions and supplies of water and electricity. The tightness of its grip may have varied, but no one can doubt the continuous reality of Israel's grip on Gaza. The court's legal holding from 2004 remains good. A similar point is to be made here. What Israel is doing in Gaza, it is doing in territory under its own control. Its actions are enforcing its occupation. The law on self-defense under Article 51 of the United Nations Charter has no application. But that is not the main point. The main point is much simpler. It is that no matter how monstrous or appalling an attack or provocation, genocide is never a permitted response. Every use of force, whether used in self-defense, or in enforcing an occupation, or in policing operations, or otherwise, must stay within the limits set by international law, including the explicit duty in Article 1 of the Convention to prevent genocide. South Africa believes that the publicly available evidence of the scale of the destruction resulting from the bombardment of Gaza and the deliberate restriction of food, water, medicines, and electricity available to the population of Gaza demonstrates that the government of Israel, not Jewish people or Israeli citizens, the government of Israel and its military, is intent on destroying the Palestinians in Gaza as a group, and is doing nothing to prevent or punish the actions of others who support that aim. The point is not simply that Israel is acting disproportionately. The point is that the prohibition on genocide is an absolute, peremptory rule of law. Nothing can ever justify genocide, no matter what some individuals within the group of Palestinians in Gaza may have done, and no matter how great the threat to Israeli citizens might be. Genocidal attacks on the whole of Gaza and the whole of its population, with the intent of destroying them, cannot be justified. And no exception can be made in a provisional measures order to allow a state to engage in actions that are capable of violating its obligations under the Genocide Convention. It is unthinkable that a court would ever do such a thing. That is the simple point in this case. Genocide can never be justified in any circumstances. Israel's actions will be examined closely and methodically at the merits stage, when the court will want to hear what Israel has to say in its defense. What matters now is that the evidence indicates that Israel's actions have violated its obligations under the Genocide Convention, that they continue to violate them, and that Israel has asserted that it intends to continue them. Israel may say that it will comply with all of its obligations under the Genocide Convention, and that orders from the court are not necessary. But in previous cases, the court has held that such unilateral statements do not remove the risk of irreparable prejudice or obviate the need for a court order. In this case, one reason for doubting the efficacy of any such unilateral undertaking is Israel's apparent inability to see that it has done anything wrong in grinding Gaza and its people into the dust. Another reason is that a departure from or reinterpretation of any unilateral undertaking by Israel may lead to consequences so appalling that the risk simply cannot be taken. But there is a third reason. As was noted during the submissions to this court in the case concerning the reservations to the Genocide Convention in 1951, quote, the obligation to submit disputes concerning the interpretation or execution of the convention to the International Court of Justice was regarded as one of the prime guarantees of the due fulfillment of the basic obligation to prevent and punish the crime of genocide, end quote. The role of the court, which unusually extends not only to the interpretation and application of the convention, but also to its fulfillment, is pivotal. In addition to their substantive obligations under the convention, it is vitally important that states respect the court and their procedural obligations. This is not a moment for the court to sit back and be silent. It is necessary that it assert its authority and itself order compliance with the obligations under the Genocide Convention. Indeed, it is hard to think of a case in recent history which has been so important for the future of international law and of this court. Madam President, members of the court, that concludes my submission. I thank you for your attention, and unless I can help you further, I ask that you call on South Africa's agent to read out the request for relief. If you are watching this, thank you for listening. Thank you for paying attention to this very important issue. I urge you again to go to the links in my description and watch the actual speeches themselves at the International Court of Justice. They're very powerful, coming from the lawyers' mouths. They're much better speakers than me, and there's just also this sense of significance in seeing it happen. I think it's incredibly significant that South Africa, with its history of apartheid, is the country bringing this case against Israel. I'm not going to do much to justify my reading of this. If you're not willing to listen, you're not willing to listen. I will say, though, that there are things you can do. Some very simple things include checking out the link to the BDS movement website in my bio. Boycotts can be done personally, but they can also be organized. You can convince your school or your employer to stop using certain products, stop buying certain technologies, things like that. Also, Palestinians have been repeatedly calling for people to just share their stories, to share information that they are sharing from their phones and such. In Gaza, there are people who work very hard to get phones and SIM cards to people in Gaza so that they can share evidence of what's happening. Obviously, you can write to your representatives, the current, or call them. The current push is mostly for a ceasefire, that is a mutual agreement between Israel and Hamas to cease fighting. That has been vehemently, viciously opposed within the United States, and I think it says something that a simple call for an end to fighting on both sides is considered to be so outrageous. I think it really says something about who our leaders are and what they actually care about. But we cannot stop putting pressure onto them because it's being noticed. The boycotts are being noticed. They're having a noticeable effect on some companies. And the demand for a ceasefire is slowly growing among politicians, very slowly, but nonetheless, and they are all recognizing how popular this viewpoint is and how much it affects their electability. So do everything you can. There's so many things you can do outside of what I've just listed. Those were just sort of the simplest starting points. Also a general piece of advice that applies in any political situation is to do things together as a group, to plan things together, and to do them locally. You know, there's always something wherever you live that you can do. You can look up organizations that are advocating for the end of this genocide and see what they're doing in your local community, or you can read up on what global and national organizations led by Palestinians have called for, to see how you can implement those things locally. Of course, it's always great to bring it to your state and federal capitals too. I have been mostly speaking of America. I know that the political situation is very similar in many European countries and Anglophone and what are considered Western countries. So this will probably, that advice will all apply to some degree to all my international viewers. Thanks again.